Hello? Yeah. Um, Good morning, the Attorney General and the Honorable Minister of Justice and Attorney General of the Federation, Abubakar Malami, Senior Advocate of Nigeria. Good morning, President. Good morning, Chairman, Presidential Communications Team, and the other members. Good morning, my colleagues and our stakeholders watching us online. It's my pleasure to welcome you to the 67th edition of the State House briefings coordinated by the Presidential Communications Team. You will agree with me that the season that we are in now, the topic of discussion is the 2023 general elections. In less than 48 hours from now, the polling booths will be open and everybody will get towards electing Nigeria's next president as well as members of the national legislature. It is on record that President Muhammadu Buhari has always said that it is his desire to leave for Nigeria a legacy of a credible electoral system. The briefing today will have the Honorable Minister of Justice and the Attorney General, Abubakar Malami, SAN, who will update us and the general public on the role of the judiciary and what the judiciary will do, the role they will play in these elections, highlighting the key judicial reforms that have been put in place by the ministry to ensure adherence to the rule of law as it relates to these coming elections. On this note, I would like to invite the Honorable Minister. As usual, he will come and speak with us and he will address some of the concerns arising from his presentation. Honorable Minister, please, you may wish to come and speak with us.
Please be seated. Distinguished members of the press, ladies and gentlemen, good morning. Before proceeding with the presentation relating to the electoral process in the Nigerian context, let me take the opportunity of introducing the team that is with me this morning and communicate to you the liberty to throw questions to the team members in the event the need for so doing arises at the conclusion of the presentation. So with me is the Permanent Secretary and the Solicitor General of the Federation, Mrs. J.D. Abba Beatrice. She's here with me. And then Mr. Biodun Aikomo, Special Advisor to the President on white-collar crimes, financial crimes, is equally here. And then one of your own, who perhaps by accident is on the other side of the divide, Special Advisor to the President on Media in the Office of the Attorney General, Dr. Umar Jibrin Gwandu. Now, coming to the topic under discussions this morning, which is briefing on judicial reform and the impact of the reforms on the 2023 election. I think the starting point for proper appreciation of the effect and impact of judicial reforms and justice sector interventions is to look at it from the historical perspectives. The historical perspectives will give you an idea as to why the justice sector intervention, why successive electoral reforms are necessary in view of our peculiarities associated with the accommodation of democracy and democratic process as a system of government. Historically, the first election that had taken place in Nigeria was in 1922. And then thereafter, in 1920. And then thereafter, the spirit of election and electoral reforms and electoral legislations for that matter was accommodated in the 1922 Clifford Constitution. It was followed up with additional legislations in 1951 known as Electoral Regulations for Election. And then periodically, things kept taking shape in terms of being regulated by electoral legislations. And in 1998, for example, a fundamental amendment came into effect on account of which the military now dissolved what was then known as NACON and introduced INEC, which is what we are having today as a body legislatively saddled with the responsibility of the conduct of election. I have labored to give you a background information, but what I am trying to achieve arising therefrom is to bring to your understanding and notice that election and electioneering processes in Nigeria were products, 1, of constitution, 2, incidental legislations, including ancillary and subsidiary legislations that comprises of the Electoral Act in its own right, election guidelines periodically being issued by the election bodies, among others. So the bottom line is to state in essence that what we have as an election in the polity and in the Nigerian context is a product of law, product of legislation, product of constitution, product of incidental and ancillary legislations called subsidiary legislations, inclusive of guidelines. Now, after 1998, when NACO, National Electoral Commission, was dissolved and INEC was put in place, we have had 6 elections that had taken place, and we are indeed having the 7th election come 25th day of February 2023. The first election was in 1999, regulated by constitution, law, and ancillary legislations. The second election was in 2003, regulated by the Constitution, Electoral Act, and ancillary legislations. The third was in 2003. In 2007, we had one. 2011, we had one. 2015, and indeed 2019. And then we are now looking towards the 7th in the consecutive series of elections that have held in Nigeria, all of which were functions of law comprising of the grand norm legislation, which is the Constitution, law relating to Electoral Act, law relating to ancillary acts. Now, coming to the impact of legislations over have the justice sector as it relates to the election. Generally speaking, all these laws, and indeed the fact that series of legislations that have been coming around over time, were aimed at addressing certain mischiefs, bringing about the desired perfection in the system out of desire for us to have an efficient election that eventually could stand the test of time, both in terms of international best practices and in terms of making the votes of Nigerians count. So the major issues over time that impeded the fair and credible election that we have been battling over time through legislations to address were many, multiple, and multifaceted. Among them, there was lack of consistency in judicial decisions, for example, affecting the electoral matters, including the widespread distortion of the time-honored judicial practice and stare decisis in view of the overwhelming number of conflicting judgments, for example. Delays in adjudicating, whereby you have a free election matter pending in court for over 10 years, even when the tenure for governor and indeed the president is 8 years. You equally have lack of internal democracy among the political parties. You equally have problems associated with the use of illicit funds in the electoral process, delay in timeline for issuing notices of election, and associated things. So all along the electoral process, the legislations arising therefrom were aimed at addressing one mischief or the other. For example, in 2010, we had problems associated with indiscriminate substitution of candidates by the political party. Through internal democracy, there was supposed to be a system of primaries that will now return a winner. But along the line, we were living witnesses, as at 2010, for example, of a situation whereby, through the internal democratic processes, someone emerged as a winner of the primaries. But along the line of transmitting names to INEC, the name of the winner is arbitrarily removed and substituted with someone perhaps that had at no point participated in the primary election. It became a problem that needs to be addressed, and then arising from the Electoral Act 2010, the need to now address that particular mischief arose, and then by way of an amendment to the Electoral Act, a provision is made to the effect that a candidate can only be substituted through cogent, verifiable reasons supported by an affidavit signed by the person or a candidate sought to be substituted. So that establishes the relevance of justice sector intervention, legislative intervention in shaping our electoral processes for the better. So the question now is, what is it that we have done as an administration under the leadership of President Muhammadu Buhari that has indeed added value, color, sufficiency, efficiency, and fairness and equity in the electoral dispensation of this country? My answer is simple. Arising from the Electoral Act, and indeed amendments thereto, the government of President Muhammadu Buhari had done a lot in relation to the electoral processes within the justice sector intervention that eventually translated to efficiency and perfection of what we are witnessing today in terms of election that is free, election that is fair, election in respect of which the votes of Nigerians count as far as electing the persons of their choice are concerned. Now, let me come to address the ways and manners through which that has been achieved. It was indeed a function of policy decisions. It was a function of legislations, and it was a function of political goodwill manifestly exhibited by the body language of the president all through from 2015 down to 2022, 2023. So with that consideration in mind, and against the background of appreciation and realization of the need to be fine-tuning our electoral processes, the President Muhammadu Buhari, has started by way of putting in place a constitutional and electoral reform committee chaired by Senator Namani. And the essence of that committee was to have a holistic review, assessment, understanding of the electoral system, identify the problems associated with our electoral processes, understand and bring about the ways and manners through which the mischiefs, the problems, and indeed the inadequacies associated with our system could be addressed. And that committee worked extraordinarily hard to factor previous committee reports, inclusive of that of Owe's committee, with a view to see what can be done in terms of profiling suggestion that could add value, color, weight, efficiency, and credibility onto what we do through electoral process. Again, realizing the fact that there was indeed no justice sector long-term reform associated with enhancing the credibility and quality of our election, President Muhammadu Buhari as well put in place justice sector reform plan. It is a plan that was set to look at our prevailing legislations associated with election. It is a plan that was targeted at indeed looking into the judicial processes associated with election process, among others, and doing the needful in terms of ensuring the credibility, quality, and efficiency of the system. Again, other than the justice sector reform, which was all-encompassing and not limited and targeted to the election and electioneering processes, Mr. President equally put in place what is called National Justice Sector Policy, which policy, as far as election is concerned, is to provide suggestion, recommendations, opinion as to how best and what we need to do best in terms of having a credible election, a credible and sustainable democratic process and election for that matter. So the Federal Ministry of Justice, arising therefrom, played a key role, one, in having in place a quality output associated with Constitutional and Electoral Reform Committee, Justice Sector Reform Plan, and National Justice Policy. The impact of these policies and how they have improved on our judiciary and electoral space will now be elaborated. Now, as I stated earlier, 6 consecutive elections were held from 1999 to date. They were held in 1999, 2003, 2007, 2011, 2015, 2019, and now the 7th one, which is holding, by God's grace, on the 25th day of February 2023. So, series of legislative interventions, including the Electoral Act, the Constitution, and subsidiary legislations regulated these elections. Prior to the enactment of 2022 Electoral Act, which is going to regulate the conduct of the 2023 election, INEC conducted election with the 2010 Electoral Act, which had already been amended 4 times. We had the Electoral Act in 2010, but then as time goes by, certain needs arose periodically for amendment, all targeted at achieving perfection and fine-tuning the electoral process. And the 2010 Electoral Act was amended about 4 times. Certain amendments were introduced to enhance the quality of the electoral process. So, but despite these 4 amendments that were made, still the needs kept arising for periodic reconsiderations and the need for further amendment. Perhaps by way of a cogent example that necessitated the need for amendment to the electoral legislations is the technology. Prior to 2010, the technological advancement in the system was not deeply rooted, making it important to be accommodated for electoral process. And here we are, now having technological advancement arising with the speed of light. Take, for example, the card reader that was introduced after I think around 2011 election. It was indeed a technological innovation that had the capacity to add credibility and trust to what we do through election and electioneering processes. And then, but the card reader, for example, as at the time it came about, was not contemplated by our electoral legislations, and the need arose for its accommodation. It is only logical that if you are to give a legal framework foundation for the accommodation of card reader, then the need for amendment to the Electoral Act must have arisen. Now, as I'm talking to you, there is a constitutional amendment being contemplated relating to our electoral process with particular regard to the issues of supervening interventions or impossibilities that may arise. We were not, as at 2010, contemplating COVID-19. And if, for example, in our electoral processes, a time is regulated for the conduct of certain items associated with the election, and then we have a natural intervening impossibility like COVID-19 that makes it impracticable for that act to be consummated, it is only logical that the COVID-19 has now set in to affect our reasoning in bringing about the contemplation associated with time regulation. Again, for example, if elections are conducted, and by our electoral acts, you are expected to file an election petition within 21 days. And here we are confronted with COVID intervention that makes it impossible for the system to operate. So what happened? In the absence of legislative foundation that accommodate and contemplate COVID intervention as a supervening natural impossibility, here you are, left without a remedy, even when it is your desire to contemplate it. So among the constitutional amendments being contemplated now relating to our electoral processes are indeed issues associated with factoring into our electoral consciousness, electoral legislations, the time element. So prior to the enactment of the 2022 Act, INEC conducted election with the 2010 Act, which had already been amended 4 times. Despite these amendments, and because of the failure of the previous administration to adopt the Ways Committee report, INEC, and indeed other relevant democratic institutions, such as the judiciary, struggle to undertake their responsibilities. And if we are to do justice to the electoral processes, to the institutions saddled with the responsibility of the consummation of the electoral process, it is only logical that we factor the need for periodic amendment to our legislations. So the issues over time that impeded fair, credible election, which is the new act, the 2022 Act, eventually captured, accommodated, with a view to bring about the desired perfection in our electoral processes are many. The issues include lack of consistency. We were living witnesses to the fact that at a point there were conflicting judgments in the judiciary. A federal high court in Kano will now take a decision today. Immediately tomorrow, a federal high court in Abuja, on the same facts, on the same provisions of the law that had been determined, will take a contrary decision. We were having, arising therefrom, a conflicting judgments, conflicting orders, and conflicting rulings. It is therefore, in the circumstances of these considerations, necessary that we need to bring about consistency in the determination of our cases through judicial process. And that was one of the major considerations associated with the 2020 Electoral Act. Again, at a point, right from time, we were confronted with incessant delays in the administration and determination of election petition matters. Here are people contending over who indeed is the rightful candidate for a political party, arising from the conduct of the primary elections of a party. And then matter is taken to court. The term, in the event one of them is considered as a candidate, will be 4 years. And the matter, as I'm talking to you, there are pending cases at the Supreme Court that were indeed pre-election matters associated with 2011 election. 2011 elections, pre-election matters are still pending at the Supreme Court. And then, out of desire now to address the mischief associated with speedy determination of cases, Electoral Act was amended to regulate time for the determination of cases. Constitutional amendments were effected, and then the delays were incidentally taken into consideration by a justice sector reform with particular regard to administration of criminal justice, among others, Administration of Criminal Justice Act. So what I'm trying to say in essence, the role that has been played by the justice sector as it relates to our election and election processes over time was to provide enabling legislations, enhance the quality of legislations, and put in place for the purpose of our election a process that is efficient, that is legally supported to be efficient and effective in making our vote count in the Nigerian context. When we were afflicted with COVID, the justice sector factor supervening natural issues, intervening issues, and making them part and parcel of consideration of our election and legislative process. When we were faced with delays associated with election processes, necessary amendments were factored into our electoral legislations, including the Constitution, the Electoral Act, and subsidiary legislations. When technology came about, we quickly seized as the opportunity of accommodating technology, making it part and parcel of our process of engagement with a view to have what is called efficient electioneering processes. So the issues associated with internal party democracy were being addressed as they arise. The challenges were being overcome as they arise through the legislative processes. And then delay in time sense is being eliminated. Delay in announcing results is equally been eliminated. And a lot of other electoral innovations were factored, particularly in the Electoral Act 2022. So the Electoral Act, now coming to the Electoral Act, having understood what informed the changes, amendments, or perhaps considerations of this justice sector reform associated with elections over time, I now come to the assessment of the Electoral Act 2022 with a view to identify what innovations, what new thoughts, effective and efficient thoughts are brought into it for the purpose of driving our electoral processes to perfection, driving our electoral processes to efficiency, and driving, above all, our electoral processes in the direction that the votes of Nigerians eventually matters and counts in determining their choice of leadership. So the Electoral Act, as you rightly are aware, was signed into law by President Muhammadu Buhari on the 25th day of February 2022, 1 year ahead of the 2023 election. It is important equally to state at this point that Nigeria is a signatory to international protocols on election. And by that protocol, for example, nations that are members to the election protocols, AU, for example, were in agreement that 6 months before elections, you cannot amend, alter, or change electoral laws. So with that realization in mind, we tried all we could to effect necessary amendments to the Electoral Act and ensure at the end of the day that it is indeed assented to, at least before the regulated time internationally agreed in respect of which Nigeria was committed. And that was the more reason why resources, time, and energy was now put together to ensure that the Electoral Act 2022 came into being at least a year before the election. So the implication of having Electoral Act 2022 was that it repealed the 2010 Electoral Act. For refreshment of memory, the election in 2011, the election in 2015 and 2019 were conducted on the basis of the 2010 Electoral Act, which was periodically amended, I think, about 4 times over time to address certain mischiefs. Now, a holistic repeal of the 2010 Electoral Act by 2022 Electoral Act. So the new act, that is the Electoral Act 2022, repealed the 2010 Act to address shortcomings in the Electoral Act 2010 and its amendment, some of the major changes that has transformed the Nigeria's electoral space were introduced. The 2022 Electoral Act introduced major amendments, major changes, and these changes, no doubt, transformed the electoral process in Nigeria, both technologically and in terms of quality, efficiency, credibility, and bringing our electoral process in tune with international best practices. Now the question is, what are the changes that were brought to bear, that were introduced by the 2022 Electoral Act? The innovations, changes, and amendments were multiple. For example, the financial autonomy of the Independent National Electoral Commission was established by the 2022 Electoral Act. And the implication of that autonomy is the establishment of National Electoral Commission Fund. Elections are costly, no doubt. And at certain points, we had to rely on international support, among others, to generate resources for the conduct of election. And our budgetary provisions are equally not good enough. So out of desire and realization that our democracy has come to stay, there is need for us to have an institutional and legislative framework that will now provide funding for our election and electoral processes. And that informs our decision of introducing National Electoral Commission Fund by the introduction of Section 3 of the Electoral Act of the 2022 Electoral Act is indeed the need for the sustenance of funding arrangement. The funding arrangement was introduced into it. Again, the time frame for notices about election was further enhanced to 360 days, and that was intended to address a mischief. I told you earlier that we were faced at a point with a problem of delays in in determination of cases. We were confronted with the problem of time associated with the emergence of the candidates through primaries and associated things. So a responsibility now is placed on INEC. Give the politicians sufficient time, sufficient notices for the election to prepare. So the idea of enhancing the notices meant to be given by INEC for the conduct of the election was enhanced from 90 days to 360 days. And arising therefrom, today I can tell you with precision that no pending pre-election matter is there in our judicial system waiting for determination, taking into consideration that sufficient time has been provided for such notices and for the conduct of primaries. So that is Section 28 of the Electoral Act 2022 for you. It provides additional days within which political parties could submit the names of the candidates to INEC from 60 days. The submission of names was equally enhanced from 60 days to 80 days. So that gives you an idea that the administration of President Muhammadu Buhari, as far as the election processes and our election, the conduct of our election is concerned, is an administration that is sensitive to happenings, that is sensitive to what is unfolding associated with the conduct of the election and electioneering processes, inclusive of the judicial conduct and determination of cases for the purpose of now doing the needful through legislative process. Again, the scope of election offenses was expanded by the Electoral Act 2022 to include bribery, looking at section, which is contained in section 121, undue influence, section 127, threatening, direct and indirect duress, section 22, 20, and 128. Political parties cannot hold or retain funds from outside Nigeria, at least to give Nigerians effective ownership of their election processes. Countries exist around the world whereby foreign powers come into their countries, influence their election processes by way of funding the election processes and ensuring a compromised candidate of their choice emerge as the winner of the election, who will come around to dance to their tune. Out of the realization of the need to localize our processes, out of the need to ensure Nigerians have indeed their fate in their hands, the funding arrangement is restricted and localized to Nigerians. So they cannot hold, political parties cannot hold or return funds from outside Nigeria. The Act has placed a limit on contribution by individuals to political parties. Even the local, I'm talking of the Nigerian citizens, were restricted on the extent to which they could now provide funding support to the existing political parties. And the intention is to allow for a wider participation, wider say as to who emerges as a winner of the election, so that we do not end up having at our hands a situation whereby a money bag support an election and now influence the national development by undermining them, or perhaps by of promoting his individual as above the public interest. So the sensitivity of the government of President Muhammadu Buhari as far as the election and electioneering process is concerned, arising from the manifestations of the provision of the Electoral Act 2022, is the collective ownership of a process, promotion of the public interest and collective participation as against foreign or individual, a kind of ownership of the process. Again, the interest of the disabled was equally realized over time, arising from the advocacy and agitations of the disabled, and then by way of inclusivity to the election process, Section 54, Section 49, and 54 of the Electoral Act make special provision of inclusiveness for the disabled people and different voting booths for men and women. Again, Section 84 of the Electoral Act. Over time, we were living witnesses to the fact that if a governor has a candidate for a political office, he will certainly have his way to the exclusion of the general public. And that was a time when political appointees, maybe a week or two to the election, a governor will appoint 1,000 political office holders and make them eligible to vote as delegates in the course of the election. So it was, Section 84 was introduced, it became a very serious an issue of litigation, and it was indeed a section that technically knocked out Attorney General as being a considerable contestant for the governorship. But that does not take away our public interest consciousness of litigating it and then submitting to the judicial determination out of desire to establish a point that indeed the administration of President Muhammadu Buhari is an administration that is sensitive to the public interest, submissive to judicial process, and then enforcer of judicial determinations. So arising therefrom, Section 84 was introduced, which section now limited the political influences of the political office holders in terms of elections. But then one interesting thing about Section 84 was the fact that it was indeed a section that equally stopped the National Assembly. The National Assembly has, arising from Electoral Act 2022, introduced a provision that now gives them the security of voting in the congresses and conventions. And the implication of which is that even before going to the field for the purpose of contesting, or perhaps for the purpose of primaries, the National Assembly, by that singular introduction into the Electoral Act of making them statutory delegates, will now have an age of over 1,700 votes over any other organ of government or perhaps candidate. So if the National Assembly members serving and former agree on a candidate, no power on earth can now take away their power to now be the ones that determines who becomes what in terms of candidature associated with the election. So it was in this Section 84 that has now bring about the desired sanity, the desired impartiality, and then the desired fine-tuning associated with allowing Nigerians to take ownership as against institutional consideration. So to ensure transparency in the record of votes, the new act created National Register of Voters, which National Register will be located at the INEC headquarters and at the state local government areas and federal capital territory, which is in electronic and hard copy. This is equally fundamental. Fundamental against the background of the fact that the National Register is an instrument that now establishes who indeed is a registered voter, the number of registered voters in a locality, and it is indeed what you use to establish overvoting and associated incidences that that in one way or the other affect the credibility of the election. So the quality of back-off associated with the register, both electronic and hard copy, is now sanctioned and sanctified by the provision of Section 9. The use of technology, as I stated earlier, to advance transparency and ensure voters' confidence is one of the innovations in the Act. So the Act allowed INEC to develop biomodal voter accreditation system, which is known as VIVAS, to accredit voters, verify voters' information, and transmit the results of election. And that is Section 41, 47, 62, and 68 of the Electoral Act. So by this singular act, the technological component is integrated as being part and parcel of our election processes. So challenges relating to inconsistent judicial pronouncement regarding the substitution or death of a candidate after primary elections were equally addressed under Section 33 and 34, requiring that a candidate can only be substituted if he withdraws, and a primary shall be conducted by a political party within 14 days. Even when a candidate withdraws, it's no longer a Tea Party affair for a political party to simply substitute that candidate with a candidate of its choice. The internal democratic process is now deepened by having on board a requirement that there has to be a fresh primaries within 14 days of the date, or of either the dates or withdrawal of a candidate. And that is under Section 33 and 34 of the Electoral Act. So, since 2015, the President assented to additional bills because we equally come to realize that the magic associated with the quality of an election and election processes is not limited and restricted to the Electoral Act only in its own right. We talk of the need for security, which is indispensable as far as the election processes is concerned. That makes it necessary that necessary provisions must be made for our security establishments to be alive to their responsibilities. And what is it that we come to realize? Underfunding. Police, for example, are not very well kitted. The provisions associated with the election duties are too demanding in financial sense, and there was need to address that. So what is it that we consider doing for the purpose of ensuring that we have a force, the police and associated military, associated formations that are ever ready for election duties? And then we realize the need for funding of these institutions. So arising from that, Mr. President came up with the Police Trust Fund, with a fund known as Nigeria Police Trust Fund Establishment Act 2019. And now, outside the budgetary provision, a funding arrangement is legislatively made available to support our police, support in such way and manner that they can be ever ready for election duties, among others. Again, when we said now we want Nigerians to be in exclusive control of their electioneering processes, we now restricted the idea of foreign funding and limited the local funding support. It is only logical that there is need to have laws and legislations that will give effect to that understanding, that reasoning, and support us in having Nigerians as the determiners of their fate in election processes. So we came up with what? With Money Laundering and Prevention Act 2022. The intention associated with the Money Laundering and Prevention Act 2022 is to ensure that greater visibility and transparency is brought to bear in the system. If political party A brings about funding from a foreign country with a view to now compromise on the right of Nigerians to determine their choice of a candidate, it can visibly be seen, tracked, and then addressed. So we now supported the electioneering processes with Nigeria Police Trust Fund establishment for the purpose of providing the funding to have a ready-made police force ready to support the system. We now ensure the enforcement of the funding associated with the political parties by way of enhancing the quality of our Money Laundering and Prevention Act. And we equally followed it up further with what is called Mutual Legal Assistance Act 2018. That is an act that gives us an opportunity to now pursue through legislative process any Nigerian that takes any step to undermine what we believe in, which indeed is our election and democratic process. So, what I'm laboring to state in essence, that it is only the government of President Muhammadu Buhari that has exhibited extraordinary political will for the institutionalization of democracy in Nigeria and took further steps to accommodate what it takes, both in terms of technology, in terms of necessary incidental funding to the process, and in terms of legislative framework to ensure at the end of the day that our democracy is not only institutionalized, but is indeed enhanced to the best of the qualities in terms of international best practices. So this, in essence, these interventions, both legislative and indeed political and administrative, had indeed helped INEC to be inclusive in its management of elections in Nigeria, arising from the political goodwill, legislative interventions, justice sector support by the government of President Muhammadu Buhari. So the enactment of Electoral Act, the constitutional amendments, the technological accommodations, the funding spirit were all loaded into what we have today as the Electoral Act 2022. So I rest my case, ladies and gentlemen. Thank you. Thank you, sir. Thank you. Okay. Yeah? Oh, good. Thank you. All right, thank you.
Thank you, sir. That was a very comprehensive one on the reforms we must admit. As I even carry the microphone, I see hands coming up. Let's just give the Attorney General some time to take a sip out of the glass of water before we start firing the questions. Okay, now, Horatius will take the first question. Ruth will take the second question. Dr. Leon will take the third, and Adeshua will take the fourth.
Good morning, Honorable Attorney General. Good morning, colleagues. Good morning, sir. I thought we were in a courtroom, sir. We got to a point we're lost. But thank you for taking time to explain all this to us. And for the first time, I'll say that I appreciate what has been done with the 2022 Electoral Act. The area that interests me most is the conflicting judgment, orders, and rulings. My name is Horatius Egwa. I write for the Bridge News. The area that interests me is the area of conflicting judgments, rulings, and orders. Why it's worrisome is you find a court in Lagos giving one judgment, then somebody goes to Kano to secure a counter judgment, which becomes very, it's like it ridicules the judiciary, because one is here, the other one is here, as if it's not a family. And you said you were addressing it. I really want to know what concrete step has been taken to deal with that issue. Thank you, sir.
Good morning, sir. My name is Ruth Olurumbi. I write for Bloomberg. In your presentation, you said that you spoke about time element as a consideration for a constitution amendment that you're considering. So I want you to please, if you can, speak further on these. What specifically are likely to be incorporated or go into this constitution amendment? What are you likely to remove? And what does it look like at the end of the day? Thank you.
Thank you, Sas. My name is Dr. Lee of the Nigerian Tribune. The AGF, sir, in the last few weeks, there had been an open rebellion against the administration's, the President Mohamed Buhari's administration's Naira redesign policy. I'm sure you're aware of the pronouncements of some of the state governors, including El-Rufai of Kaduna State, Ganduje of Kano State, even some that are not even governors, including Oshomole of Edo State. Essentially asking citizens not to mind the president, not to mind his Naira, cash swap policy, that their citizens should continue to use the old 500 Naira and 1,000 Naira notes despite the pronouncement of the president. Some have seen these pronouncements as treasonous, and they were meant to incite the public. And as you would have seen, there were actually people that took the advice of this, governor very seriously and went to the streets to destroy private and public properties. And in some cases, deaths were recorded. Now, as the chief law officer of the Republic, I'm just wondering, what is your perspective? Why has it not been possible to call, to hold these leaders to account over what appears to be their act of treason on the Republic? Thank you, sir.
Thank you. Good morning, everybody. AGS, sir, despite the robust laws we seem to have, sorry, my name is Adesu. I work with Arise News. Thank you very much. Despite the robust laws that we have, sir, we seem to be deficient or lagging when it comes to prosecution. And one will wonder why, especially when it comes to electoral matters. We do know that there's a bill in the National Assembly for electoral offenses, but do we have to wait for new laws for us to prosecute those who rig our elections and who cause mayhem during elections, sir?
Okay, let me start with the first question by Horatius relating to conflicting judgment and orders. Well, generally speaking, anything that has to do with judgment orders is a function of the judiciary. And I believe you very well know that Attorney General of the Federation is indeed, belongs to the other side of the divide, the executive. But notwithstanding, I will make an attempt to give you an idea as to what is being done arising from the collaborative understanding between the executive and judiciary with particular regards to the issue of conflicting judgment and orders. It became a source of concern over time, and then arising from that concern, there was indeed an engagement between the executive and the judiciary, and that gave rise to a lot of interventions, about 3 of them that I can readily remember. The first one is a practice direction issued by the judiciary, and the essence of practice direction is to bring about an order as to an uniformity and consistency in the way judiciary does its things in terms of proceedings. And then again, as you rightly know, some of these judges and justices that were alleged to have indeed issued, and deliberately for that matter, with impunity and arbitrary conflicting judgment and orders, were disciplined. And some were, I think, at a point even dismissed, right? Either the idea of discipline was equally certainly factored to mind and pursued by the NJC. And again, I believe arising from that concern, the technological component consideration by which the justices, the judiciary took steps to have justices commonly and jointly online to ensure minimization of conflicting decision and orders was equally deployed in the judicial system. So what I'm saying in essence, yes, there was concern associated with conflicting judgment and orders. 2, the concerns were indeed noticed. And then 3, collaborative actions were taken between the judiciary and the executive with a view to address concerns associated thereto. Now, the issue of constitutional amendment, I think. Your question was what other things have been done in respect of, sorry, come again, please. Yes. Mm-hmm. The possibility of, making time of essence, considerable factor in, as it relates to election and electoral processes is factored into constitutional amendment being processed at the National Assembly. For example, as to whether if indeed you are supposed to file an action within 14 days. Yeah? We are supposed to file an action within 21 days, and then there are force majeure associated with natural disasters, something like COVID that came about, and that makes it impossible for you to now file within the 21 days. As to whether time begins to run, even while the supervening natural events were there, whether time should begin to run or it should not. And I think the proposal being considered by the National Assembly is to the effect that time will not run during the during such period of supervening impossibilities. So what you expect to see arising therefrom is a situation whereby the supervening impossibilities, particularly the natural supervening impossibilities, can now be factored into consideration into the time calculation, time consideration. Yes, and then the open rebellion that was raised as an issue relating to NERA redesign policy. First, let me start by way of linking the NERA redesign policy to the ownership spirit associated with election. I tried to explain in the course of my submission that some of the provisions introduced into the Electoral Act were intended to ensure that Nigerians take effective ownership of their election process by way of ensuring that no foreign funds are allowed to influence our decision in terms of ownership, and by way of limiting the idea of, the contributions by Nigerians to the political parties. So if you are to consider extending it further, perhaps a situation whereby NERA redesign is factored into our electoral process consideration, it could equally have the possibility of ensuring that money is not allowed to play a prominent role in affecting the freedom of judgment of Nigerians. So it is about a policy, and a policy is intended, one, generally with particular reference to NERA redesign. The intention is to, I talked to you equally about Money Laundering Act, which is intended to bring about the greater visibility and transparency in what we do in financial sense. So the policy associated with the Naira redesign has a lot of advantages. Advantages associated with the fight against corruption in terms of bringing about the desired visibility and transparency. Advantages associated with sustenance and allowing the freedom of judgment of Nigerians to prevail. Freedom devoid of monetary inducement and interventions is equally part of it. But then, on the issue relating to the open rebellion, as you characterize it, one, I would like to comment more in view of the fact that the sizable portion of such considerations constitute a subject matter of litigation before the Supreme Court. But above all, as you rightly know, you equally raise issue of treason or perhaps certain undertones associated with it. These issues are usually issues that are issues of process. So you cannot rule out the possibility of investigation, but the responsibility of investigation and doing the needful arising from the weight and assessment of the implications of the statements and utterances is the responsibility of security agencies, and I believe they are doing the needful in that respect to determine whether there is need for further action. Actions associated with investigations, actions associated with prosecution, and what other measures needs to be taken in case it is their conclusion that there is need for actions to be taken relating to the utterances made. So that is the best I can say in that respect relating to open rebellion. Now, the last question, I think, it was about deficiency of prosecution, notwithstanding the robust laws that are in place. Well, the idea of prosecution, honestly, is something that you need to understand that is a function of, first, perhaps maybe a complaint, 2, investigation, 3, gathering evidence and profiling same for presentation before judicial process. So it's not a kind of, it's a process that is indeed loaded with a lot of component of consideration, other components relating to the executive, the judiciary, among others. But the true position of things is, as a system, we have been doing the needful in terms of prosecuting people that are presented, that are indeed where there exists a prima facie allegation of commission of electoral offenses in view of the fact that the laws are there. And out of desire to further enhance the quality and the reach associated with prosecution, the Office of the Attorney General has generated a fiat investing the powers in the state attorneys general to prosecute offenders in their localities. So notwithstanding having in place the laws, we equally consider the possibility of a collaborative approach by which the powers of the Attorney General of the Federation are donated to the state attorneys, all out of desire to ensure at the end of the day that regardless of how remote and where the offense is committed, something is done in that direction. We have a collective responsibility to ensure that this democracy works, and then arising from that realization, we are doing the needful. But I have told you earlier, over time, what we have tried to do is to be fine-tuning our legislative framework. So if, for example, the need has arisen perhaps to have to have tribunals or things of that nature, there are things that one cannot rule out the possibility of considering. But the truths of the matter is we are doing the needful, we will keep improving, we keep working until we get to the promised land in terms of having a perfect election. But I believe, and certainly so, that you will agree with me that what we had in 1999, what we had in 2003, 2007, 11, and 15 is certainly different from what we have in terms of the quality of our electioneering processes. So we have been evolving, we will keep revolving, and we will keep attaining. Thank you very much. And then you answer it.
Honorable Attorney General, my name is Cyril Okonkwo. I work for Voice of Nigeria.
Cyril
Okonkwo, Voice of Nigeria. The President Muhammad Buhari administration has done a lot in justice reform. But are you worried about the interpretations of these laws in the courts that might go contrary to the spirit of these laws and set precedents that will go against the intendments of these laws?
Sorry?
That will go contrary to the spirit of the interpretations in the courts that will go contrary to the spirit of this law and set precedents that might be dangerous for the nation.
Okay, thank you, sir. My name is Tony Aileme. And yes, okay.
Yes.
Thank you, sir. My name is Tony Aileme, sir. I write for Business Day. Sir, we actually want to commend you for all that has been done under this administration. But I want to ask you, sir, reflecting back from 2015 to date, what were those difficulties that you noticed in the process of reforming the nation's legal system that you tried to address and you couldn't? And what advice do you have for the incoming administration in tackling some of those issues, sir? Thank you.
Good morning, Honorable Minister. My name is Umar Aliu. I report for Code Radio International. My question is on financial autonomy, sir. President Muhammadu Buhari administration and personally President Muhammadu Buhari has been very passionate about financial autonomy for judiciary, state legislature and local government. He spoke about it several in different forums. So there is this constitutional reform going on. Sir, you are also a member of ruling party APC with 21 okay, 21 governors out of 36 is of APC. Why is it so difficult to achieve this financial autonomy for judiciary, state legislature, and local government, sir? Thank you.
Okay, good morning. My name is Gloria Umezoke from Channels TV. So I wanted to, Nigerians really would like to gain more clarity on the issue of breach of court order, because the federal government, on the other hand, is insisting that there is no breach of, the president hasn't done anything wrong. And there we believe that really there was clear perspective on this. The Supreme Court said let the 200, 500, and 1,000 naira roll out, and then the president comes on the other hand to broadcast that just 200 naira be let out. So we're just wondering, how do you perceive all of this? And really, is he not in breach? Thank you.
Good morning, Honorable Minister. My name is Bolaji Ogundele, and I write for the Nation newspaper. It might still have to do with financial autonomy, probably for the judiciary now. Some have come to see it as judgment or justice in Nigeria is for whoever can pay. And it is assumed that it is like that because probably justices are not being paid well enough. For instance, a Supreme Court judge, justice, who has a case before him for a politician who is willing to give him 1 billion naira, someone who in his lifetime might not even earn 500 million naira. Do this for me and I'll give you this much. And eventually we'll hear of miscarriage of justice. So is it because justices are not being well paid enough, or why do you think we are in this kind of situation where in Nigeria it is believed that justice is only for whoever can pay for it? Thank you very much.
Honorable Minister, before you take that, we have one question online. I'll just take it in its stride. Olu Gold is saying, is asking, please, my question is, how do we effectively tackle the issue of corrupt judges and lawyers aside from the NGC dealing with them and the lawyers being given disciplinary action by the NBA?
Yes. Well, let me start by the first question, seeking to know whether I'm worried by the interpretation and dangerous precedents, pronouncements being made in the system. I'm not worried at all, because the true position of things is that as executive and then as a government and system, as I've told you, right from 1920, when the first election held in Nigeria to date, legislations were being made, observations made, amendments effected, all out of desire for perfection. So if indeed there are interpretations or perhaps certain precedents have been said that are dangerous, my responsibility is not to worry about them, but to attack and address them frontally. And that is what we have been doing. If indeed decisions are made that we feel they do not support the better policy that will now support the system in attaining the desired result, we now do the needful by way of addressing them through legislative interventions or other options and remedies that are available in the system, which options and remedies are multiple. So the idea of worry does not arise, but the idea of working to ensure that what is best for the system is indeed attained is what matters to me most. The second question is difficulty in referring the legal system. Sorry? Oh, difficulties. Yeah, okay. The difficulties encountered in the system. One thing, the only thing that I think is fundamental for consideration as far as the Nigerian state is concerned, is we have not attained a point whereby we strike a balance between the public interest and individual interest. Here we are, for example, for the purpose of the election coming up in a few days, confronted on a daily basis with hate speeches that have the capacity to now set the country ablaze. Someone would simply sit in the comfort of his room, a kind of sending fake messages, even when he knows, in fact and in law, in all sincerity, it was false and fraudulent, thereby promoting a personal interest to the detriment of a public interest. So the major regret is realizing that most Nigerians do not understand the art of striking a balance between the public interest and the public interest. Public interest, you have no reason whatsoever to subject the life of over 200 million Nigerians to unnecessary trouble on account of your act, all out of killing for freedom of expression. And then when you talk, someone will now say, I am faced with a question on rule of law. that an order is made by a court and then you are not obeying it. Do you now, for goodness sake, promote, support, and establish a right of an individual that is setting the life of over 200 million in danger out of purported respect for freedom of expression? So the major regret, if any, is the fact that people tend to promote individual interest as against the public interest. And until we now come to realize that there are limits to what you can do as an individual, regardless of what claim of right you have, which will eventually affect the collective interest of over 200 million people, until we come to realize that the interest of 200 million Nigerians prevails over the purported freedom of movement, liberty, and expression of an individual, it is going to be a very difficult process and exercise for us. So if there are perhaps maybe challenges or indeed difficulties associated with it, it's a situation whereby, for example, now when we are talking of Naira redesign for that matter, simply because I have succeeded in raising, perhaps legitimately or otherwise, 200 billion, I can now come out to fight a system that is battling to address transparency, to address visibility of the process out of desire to limit corruption. Is it the limitation of corruption that will now translate to having funds at our disposal arising from the transparency and visibility of the system that can be used in the infrastructural development for the benefit of 200 Nigerians that matters? Or perhaps submitting to the demand of an individual that perhaps illegitimately, unlawfully, fraudulently, deceitfully, perhaps acquired 200 billion, and then he now set aside 100 billion because he has greater noise-making capacity of compromising the press to start blowing rule of law that we will now submit to the interests of an individual over and above the national interest that will now support us in ensuring deepening democracy, in ensuring having in place a corrupt-free society, in ensuring having in place resources that can now translate into infrastructure. So it is about people, limited number for that matter, that have succeeded in having at their disposal resources that they are protecting. And then again, forcing a compromise on a policy that is beneficial to 200 million Nigerians. Our interest is not to a fraction but to a whole. And the whole is the Nigerian population of over 200 million and not limited number of individuals that feel a policy should not stand simply because it does not accord with their desires and with what they expect to see operating in the system. So that is my take on that. And then the financial autonomy, why is it difficult to achieve? The compromise, I have just raised an issue of an individual forcing his way over the majority on account of the resources at his disposal. So it is about, when you talk of autonomy and you talk of finances, it is all about the finances. The answer is in the question. You talk of the financial, you talk of autonomy. Then here are people that believe in one way or the other, their finances are going to be compromised, or the volume of finances at their disposal is going to be limited, and they fight it. So that is the issue. But the true position of things is it is difficult because the compromise, because of the fact they will end up having the volume of the finances and funds available at their disposal compromised. But then ours is to ensure things are done, and then arising therefrom, we took steps to effect constitutional amendment to Section 123 of the Constitution to ensure the autonomy of the legislature, the autonomy of the judiciary, and we further supported it with an executive order number 10. And we are doing, and will continue to do, to ensure at the end of the day that the system works efficiently, and indeed, the system works efficiently. We will continue to do it. We will continue to push by way of legislative framework, by way of executive intervention, by way of political interventions, among others. which one is the next one? Breach of court orders. Well, corruption and in the system, I do not think corruption indeed is exclusive to the judiciary. It's all encompassing, all pervading in the system. But the true position of things is without being exclusive and restrictive in consideration, what we are doing in terms of the fight against corruption is all encompassing. Both in terms of institutional interventions, you have institutions like EFCC, ICPC, the police are there, and code of conduct. They are all there by way of institutional intervention to ensure that corruption is reduced to the barest minimum. Again, in terms of actions and enforcement, we are taking steps to prosecute, and that prosecution has been ongoing to such an extent that as at the time the EFCC was established, I think around 2003, is it? Or up to around 2015, they had at their, to their credit, a record of conviction of around 106 convictions. But only this year, I'm talking of 2022, they have over 3,000 convictions. So that, in essence, establishes a point that we are making progress. We are recording successes as far as the fight against corruption is concerned. But that has further been consolidated the more by the international recommendation and commendation accorded our president upon, on account of his appointment as the champion of anti-corruption by the African Union. And that was further reconsolidated by international bodies, inclusive of United Nations Office of Drugs and Crimes, which equally assessed Nigerian corruption index and come to the terms with the reality that among the 17 establishments and institutions assessed in terms of corruption, 17, there has been a tremendous percentage of success and enhancement in the success associated with the fight against corruption in respect of 15. So regardless of the dimension and the way and manner you look at it, we are making and recording huge successes. And that can further be visibly seen arising from what we have been doing in terms of recovery of illicit funds. We have a record, first, of recovering over $322 million in 2017, which set the foundation of what we are witnessing today as the effort of the president in taking people out of poverty by all the establishment of the social intervention programs. So the $322 million were applied in frontal attack of poverty and ensuring the support for employment in the system. We equally recorded further success as far as the fight against corruption is concerned by way of deploying additional $311 million recovered, illicit fund, recovered and repatriated on infrastructure, which funds were indeed applied in the completion of the second Niger Bridge, progressing with the work on Abuja-Kano Expressway and Lagos-Ibadan, among others. So regardless, and then if you are talking of prevention, I have demonstrated to you how the Money Laundering Prevention and Prohibition Act came into place, what we have done relating to incidental legislations that were put in place, proceeds of crime bill, and a lot of other legislations. So regardless of the way and manner you look at it, we are doing the needful in terms of the fight against corruption, not only within the judiciary, but in fact within the system at large, by way of having institutions associated with the fight against corruption and supporting them to perform, by way of having the necessary and relevant legislations, by way of indeed having in place policies that have translated into enforcement and prevention of corruption, among others. So that is my take on it. And more so, we equally come to realize the fact that as far as the judiciary, if you want to take it in exclusivity is concerned, there is need to ensure that someone is adequately equipped for the purpose of performing. You give someone and expect much from him. So with that in mind, we equally have taken steps to ensure that the welfare of the judiciary is enhanced, and then Mr. President has given approval in principle for the enhancement of the welfare. And again, a further process associated with the transparency and integrity of the system is being deployed in terms of recruitment of judges, to such an extent that agencies of government, including the anti-corruption agencies, are involved in filtering and clearing officers aspiring and vying to be judicial officers. So a lot of policy decisions were generally broadly brought to bear in terms of the fight against corruption, generally, and then exclusively as far as the judiciary is concerned. So we are doing what it takes in terms of ensuring the integrity, quality, and the efficiency of the system generally, with particular regard to the scourge associated with corruption. Now, on the issue of corrupt, I think it's answered, right? I believe I'm done, right? Thank you very much. Which one is that, please?
Okay, in breach.
Well, your question can best be answered within the context of what constitutes a rule of law in the Nigerian situation, where an order is made by a court. You have multiple options. But let me state, before even addressing the issue of the options available at our disposal as a government, the fact clearly that we are not in breach of any order made by the court, inclusive of any order associated with the Naira redesign. We are not in breach. I believe, I'm not a banker, but you have not gone further to establish which bank is it that you have gone to present a 1,000 or 500 Naira note that has been rejected. So we are not in breach. So, but then assuming we are in breach, the fact remains that this matter is sub judice, as you rightly know, it's been contested before the Supreme Court, and when an order is made, you have multiple options within the context of the rule of law. One, you are entitled as a matter of right, if the facts and evidence support your position, to apply for setting it aside. The position of the law, legal jurisprudence is clear. Once you are attacking, and then seeking for a setting aside of an existing order of the court, you cannot be said to be operating in breach when you presented your application for setting aside. If the court is not an apex court, you equally have a right of appeal and support the right of appeal with an application for stay of execution order. So the bottom line of what I'm trying to state is the matter is sub judice, and within the context of this rule of law, we are doing the needful as a government in terms of ensuring that the right of the government within the context of the Naira redesign is being protected. So we are not in breach. Thank you very much.
Thank you. Time to appreciate the Attorney General and the Minister of Justice, Abubakar Malami, SAN, CON, and his team for coming. I would like to also salute his courage, his confidence, his conviction at coming to address this briefing at a time like this. You know, if he didn't have the courage, there was every reason to decline to come. But he came and he has taken all the questions. So thank you very much. We quite appreciate it. With him is the Solicitor General of the Federation and Permanent Secretary, Ministry of Justice, Mrs. Beatrice J.D. Agba, OON MNI. Welcome. Also with him is Mr. Abiodun Aikomo, Special Assistant to the President on Financial Crimes, Office of the AGF. Welcome, sir. Dr. Umar Jibril Gwandu is our own friend, our own colleague, Special Assistant to the President of Media and Public Relations, Office of the AGF. Welcome. Mrs. Modupe Ogundoro is Director Information. You're welcome. Let me also thank members of the Presidential Communication Team, Madam Garba Sheu, Ogemodi, thank you. Biodun Oladunjoye, I've seen Sir Atta there. Is Tijani there? Okay. Then I've seen Bosua, James, yes, and Uche. Okay. Everyone in the PCT. This is the 67th edition. You have done well putting this together week after week. Very soon we are going to break the tape. We may not have the Attorney General here again in the life of the administration, so we thank you. Thank you for coming. Thank you very much. Let me also thank our friends and colleagues in the media for coming. Thank you. We have really had bad cases of misreporting since we started, and we have done 67 editions. So I want to appreciate you and also appeal that today too, let there be fidelity to truth, to fact when we are reporting. Let's not twist anything for sensationalism. Let's just state, let's just state it as it is. We thank you very much and hope to see you again next week. Thank you. God bless. Thank you. Usually we take a group photo. We take it outside.